Welcome, ladies and gentlemen. Welcome to the top 10 estate planning mistakes and, most importantly, how to avoid them. So for the next 7 hours, but for the next 90 minutes, we're going to be talking about the top 10 estate planning mistakes that I've seen in 22 years of practicing law. Before you, you've got some materials. You have a questionnaire, and this is where you can fill out your name. And as we go through the materials, I'll be mentioning some things like setting up my living trust, review of my existing living trust, and some other things here. As I mention these, you can go ahead and check the bubble, whatever looks good to you or is of interest to you. And then right behind that, we have the printed materials. And this is the top 10 estate planning mistakes and how to avoid them. We're going to spend a few minutes on the first page, and then beginning on the second page, we're going to talk about the top 10 estate planning mistakes. And what you can see here is we've got letting your family go to, and then a blank. And then you can fill in the word, kind of like for those of you who go to church, when you get the handout, you can fill in the word. So you guys ready to get started? Yep. All right. The first thing the state bar makes me do is put up a disclaimer. I am an attorney. My lips are moving. Words are coming out of my mouth. It's all true. This is not legal advice. And I want to tell you a little bit about myself and my qualifications, and frankly why you should be listening to me, as well as Ed Goodson, who's another attorney at our firm here, and he's in the back. Does anyone know how many people there are in the state of California? Any guess? 14 million? Who said 14 million? You're half right. Actually, you're third right. There's some chocolate for you. There are about 39.6 million people in the state of California. 39.6 million people. Do you know how many lawyers there are? 14, right. Too many, right? There are about 180,000 people who are currently licensed to practice law in the state of California. And the State Bar of California does something really cool that not every other state does. They have a certified specialist program. And it's much like in the medical specialties. Anyone here in the medical field or has worked in the medical field? I see a couple hands. In the medical field, they have board-certified surgeons, board-certified internal medicine physicians. They've got a cardiologist. We have a similar thing with lawyers with the State Bar. It's called the Certified Specialist Program. So we have certified specialists in criminal law, we have certified specialists in family law, in immigration, and we also have certified specialists in estate planning, trust, and probate law. Now, when you go out into the ether to look for a lawyer, right, you're going to want to find a certified specialist in estate planning, trust, and probate law. Why? Right? Because this stuff is really complicated. As we go through this, you really should hire an expert. You should not hire a lawyer that does a divorce case at 8, that does an immigration case at 10:30, does a criminal case at 1, and gets around to doing your estate plan at about 4:30 in the afternoon. That's not the kind of lawyer you want. You want a specialist. Here's the problem. Many of you live who here lives in a rural area? Anybody? Okay, so a fair amount of people live in a rural area. There aren't hardly any certified specialists in rural areas. They're really hard to find. They tend to congregate, I'm one, right? I'm getting there. They tend to congregate in the cities, and they tend to be close to the coast. Out of the 180,000 lawyers that are certified as a specialist by the State Bar of California, only 900 are certified in estate planning, trust, and probate law. That's less than 0.5% of all lawyers. And that's about one lawyer for every 44,000 Californians. So we got a lot of work to do as certified specialists. I am a certified specialist, and so is Ed Goodson there at the back of the room. We each have over 20 years experience helping clients avoid these mistakes that we're going to be talking about. What do you guys see here? Rat's nest. Somebody says a mess, a pile of rope, for literal interpretation. Well, clients come into our office and they come in with a mess. And some people, they say, Jim, I don't even know where to start. I did a Google search. I Googled living trust. I heard someone here says, I went online to do a do-it-yourself thing. I don't even really know where to start with this whole process. Some people come in and they say, we did our estate plan 20 or 30 years ago when our kids were young, and now our son has gotten into some trouble, and our daughter's married a guy that we don't really approve of, right? How do I deal with that? I don't even know where to start with that. So when clients come in, we help them through these thorny messes. This is a great slide. There's what we know, there's what we know we don't know, but what gets us into trouble? What you don't know, Isn't that right? It's been said that the smartest people know everything that they're not good at, right? The smartest people know everything that they don't know. My job today is to make this orange a little bit smaller, the green a little bit bigger, but I want to make this blue a lot bigger. I just want you to raise awareness. I don't necessarily want you to walk out of here as an expert, but I want you to walk out of here empowered, that you know how to choose the right person. That's really the bottom line. You know, this is true. We're surrounded by data but starved for insight. Another word for insight is wisdom. I'm going to give you, after 20-some years experience as a lawyer, helping people with their estate plans, the top 10 mistakes that we see literally, Ed, on a daily basis. I mean, we just see people, I don't want to say an hourly basis, but it's, 3-4 times a day. We're going to talk about 4 time periods. I hope everyone is at number 1. I hope nobody's at number 2, okay? This, I will say, falls within the single largest class of mistakes, is failing to plan for incapacity. No one wants to think, gee, if I get a stroke, what happens? What happens if I get a stroke and I go to a nursing home? How much is a nursing home? Any 5,000? Who's 6,000? 6. Okay, you're all right. It ranges. It depends on where you are. Does everyone know where Barstow is? Does everyone know where San Francisco is? Which is going to be more expensive, right? Exactly. The state of California publishes something called the average private pay rate, and currently it's slightly over $8,000. That goes up, on average, in the state of California, slightly over $8,000 a year, and that tends to go up every year. So it can be very expensive. People oftentimes don't plan for that. Next question is, how are you going to pay for it, right? That's kind of a scary thought. If you have questions, I ask that you hold the questions. There will be a Q&A at the end. And make sure you silence your cell phones. That kind of always helps. But are we ready for the top 10 estate planning mistakes? Can we get a drum roll, please? All right. Okay. Coming in at number 10, letting your family go to probate. Of course, big mistake. Probate's a disaster. Okay, let's say we've got Bob here. And what does a typical house cost? Just to throw out a dollar amount. Typical house price. $500,000. Let's say Bob's got a $500,000 house, and he has $500,000 in the bank. He's a millionaire. It's not quite what it used to be, right? How much interest is he getting on his CDs? Right? He used to get interest on his CDs. He dies with a will. Bob Sr. here dies with a will. Bob Jr. goes down to the bank and says, Bob's died. I'm supposed to divide everything up between myself and my brother and my sister. Give me the money, bank. What are they going to say? No, get lost. We need a court order. We need probate. Well, what are you talking about? Well, you have this will, but unfortunately a will, and this is very, very important, a will is not a binding, legally effective document until a court makes an order that it is a person's last will. So when you think of a will, think of court order. And where do you get a court order? You got to go to probate court. What the heck is probate? Well, probate is Bob Jr. goes to the lawyer's office. The lawyer sits down with Bob Jr. and says, well, you need to go through probate. Bob says, okay, what's that? Well, let me get this 4-page form and let me fill it out. You sign here. We're going to file this with the court, and our first hearing will be sometime between 4 and 6 weeks from now. And you'll go down to the courthouse with me. You'll have to go through a metal detector, kind of like you're going. Has anyone here been to a courthouse? Yeah, it's like you're going to the airport. You got to go through a metal detector. You have to show up on time, and you have to pray that the judge will have done the judge's job, and that your lawyer will have done his or her job, and that all the stars will be aligned, and you will get your order for probate. Now, depending on the county that you're in California, sometimes it takes 2, 3, 4 weeks to actually get the order after the hearing. That's a hassle. You have to go through the same process to close the estate at the end of the probate. What if Bob? Oh, by the way, how much does all this cost? Ed, what are the probate fees on $1 million estate plan?
It's about $48,000.
$48,000. That's $23,000 in attorney's fees. Woohoo! Right? $23,000 goes to the executor. So a lot of people don't realize this. The person that serves as your executor also can get a big fee. And there's $3,000 or $4,000 in court costs. What if this is not a casket? What if this is a hospital bed, a nursing home bed? right? Can Bob Jr. take Dad's will down to the bank and say, Mr. Banker, I'd like some money to pay my dad's $15,000 a month nursing home bill? Now, why did I say $15,000? Because Bob Jr. doesn't want his dad going to the crummy place. He wants to go to the nursing home where all the nurses are really good looking and the bar opens at 4, right? That's the nursing home he wants his dad to go to. And that's $15,000, but to go through a court process to get access to the bank account is something called a conservatorship. In California, we use the term conservatorship. That means a proceeding for somebody who is living over the age of 18. And Ed, what does a conservatorship cost?
If everything goes right in the first year, it's about $12,000 to set up, and then every other year there's an accounting cost about $6,000 to do.
Yeah, very expensive, very expensive. It's not uncommon for people to go through a conservatorship and then have to go through a probate, so you get both. So what's the alternative? You know, we're talking about all the downside. What's the alternative? Well, the alternative is creating a living trust. And a living trust involves three components. There's you're the creator, and the term we use is grantor. Now, what does that mean? Well, that's a tax term, grantor. So when we use the term grantor connected with the trust, that has a specific tax meaning. But what we're really talking about here is a living trust, also known as a inter vivos trust. That's Latin for between the living, hence the term living trust. It's between living people. So my wife and I create a living trust, and it's kind of like this vessel here, this holder. And into this living trust, we put our house, and we put our savings accounts, and we put our stocks and our bonds and our mutual funds. We don't put our IRAs, 401ks, 403bs, TSAs, TSPs, annuities, or life insurance in the living trust. We'll talk about that a little bit later. But we put our house, our investments, our savings in the living trust. And if I become incapacitated, if I get sick, my wife takes over as trustee, right? But if she dies, who's the next person in line? That's the successor trustee. And sir, what's your first name?
Kevin.
Kevin. We've named Kevin to serve as our successor trustee. So picture this. I've had a stroke. I'm in a nursing home. My wife has passed away. So we're no longer able to be trustee. We stopped being trustee. I'm still alive. So I'm still the beneficiary. Kevin is my trustee. And Kevin, you go ahead and take that. Now don't use any of that money for you. You're a fiduciary, right? You've got to use that money for my benefit. So you go ahead and pay that $15,000 a month nursing home bill, because again, I'm in the nursing home that has what? Good-looking nurses in the bar that opens at 4, not the crummy place, right? So give me pay that $15,000 for my benefit. When I die, I'm sorry, Kevin, you're no longer the trustee. This trust is moving to the great state of Nevada. Now, why would I put a trust in Nevada? Why would I move that trust to Nevada? That's right. Nevada doesn't have state income tax. California has state income tax. We have the highest in the nation. We'll talk about that a little bit later, but instead of my kids getting it all out at once, where it's not protected from creditors, predators, and divorce, it goes into a trust where it's doled out over time. And it's protected from divorce, and it's protected from my children's creditors. Let me tell you a little bit about what I mean with creditors. I'm not talking about not paying your bills. What I'm talking about is sometimes in our society, we're held responsible for things that aren't our fault. Does that make sense? Mm-hmm. So sometimes you have legal responsibility for something that's not your fault. The United States is 5% of the world's population. 95% of the world's lawsuits are filed in the United States, not the state of California. 95% of the world's lawsuits filed in the United States. If you're worried about getting sued, we're going to talk about creditor protection down the road. Some people are just generally worried about getting sued, but we'll talk about that in a little bit. So you're the grantor, you're the creator, you're the trustee. You're always going to be the creator. You will be the trustee until you stop being the trustee. You become disabled, you pass away or resign. You will be the beneficiary for as long as you live. You can't take it with you, right? It doesn't get buried with you like the Egyptians. It doesn't get burned like the Vikings, right? In our society, it goes to some people or some other organization. Let me tell you a little bit about my family situation. My wife is the primary caregiver for her mother, who has advanced Alzheimer's, lives in the home, and my father-in-law, who is a retired Chief Master Sergeant from the United States Air Force, is really good at giving orders, not so good at taking them. And he is the companion for his wife, my mother-in-law, but really my wife is the primary caregiver. And our youngest daughter has now helped out my wife take care of her grandmother. And we have a video here from the Alzheimer's Association that I'd like to show. And it's got some surprising little tidbits of information. Boy, it's heavy stuff, isn't it? One other thing, when you do a living trust, my wife and I have created a living trust. We've also done a will. We've written up a will. Now, if you have a living trust, why do you need a will? Well, we have a will so that if I happen to have a $10,000 certificate of deposit, this is a $10,000 bill. It's fake, so don't kind of run up here. By the way, take one of these, and if it works at Starbucks, please let me know. So this is a fake $10,000 bill. If I have a $10,000 CD and I pass away, I want that CD going into my trust, right? Well, how it gets to the trust is I have a will that leaves everything to the trust, if that makes sense. If you have firearms, we typically distribute firearms from the will. We don't put firearms in the trust. Firearms law is changing in the state of California. The bottom line is the state of California does not want you to own firearms. That's my view. Or have ammunition. But that's a specialty item that we can deal with on a one-on-one basis when we meet with you guys. Mistake number 9, belief that all trusts are the same. So the analogy I use here is who packed your parachute. Has anyone here jumped out of an airplane? Anybody? Boy, no thrill seekers. We generally get a couple of people who jumped out of an airplane. If you jump out of an airplane and your parachute doesn't open, what happens? Yeah, it ruins your whole day. Any pilots in the room? All right, great. So I'm a 3rd generation pilot. I've got my private and instrument rating, and both my parents were pilots. My mother was an air taxi pilot in Alaska in the 1960s. I think she might have been the second woman to do that. And my grandfather, my mother's father, was a pilot. And so when you jump out of an airplane, you don't pack your own parachute unless you have a special designation, certification, special training. Right, sir? You served in the military? Yeah. When you jump out of an airplane, you're not packing your own parachute. Someone else is doing that. Why? Because when you pull the ripcord, you want it to open. This is where we talk about the different types of trusts, and really a really big warning, don't do this yourself. Abraham Lincoln said, if you represent yourself, you have a fool for a client. Okay? Lawyers do not represent themselves. Wise lawyers don't represent themselves. If you're not a lawyer and you try to do estate planning on your own, you don't know what you're getting into. If you go online and look up, hey, trust or living trust, you're going to get all kinds of trusts. So there is a living trust between a married couple, a living trust for a single person, a living trust that's a single person trust for a person who's married. There is an irrevocable trust, or lots of irrevocable trusts. What we're talking about here are revocable trusts. So a trust that you can amend or revoke. If you have an estate plan that's old and you say, gee, we really need to update this estate plan, and you've created a trust. My trust is the Cunningham Family Living Trust dated March 20th, 1998. I've changed that trust 3 or 4 times. I've done what's called a restatement, which is a great big amendment. So if you have a trust that's old and outdated, and you want to change it, after you come here you go, wow, boy, we need to change stuff. You can do what's called a restatement of trust, so you don't have to transfer your assets from one trust, from your old trust to your new trust. Does that make sense? So you keep your old trust and you just change the terms of your living trust. So here's our 12-step quality control process. This is not a 12-step program. This is very important. Other lawyers don't have this process, and let me go through this with you. Number 1 is seminar preparation. I'm a big believer in education. My grandfather started college in 1928. What happened in 1929? Depression, right? He stopped going to college. He ended up going back to the farm, ended up moving up to Detroit, became a factory worker, tool and die maker, General Motors plant, and put 3 sons through college, no student loan debt, on a factory worker's wage. Amazing. Isn't that awesome? I mean, just a real testament to hard work and determination, and I guess college was a heck of a lot cheaper back then. So all three sons became teachers. My dad later became a lawyer. We have a culture in our family of learning. We're all lifelong learners. I really believe I'm a strong proponent of educating clients. I'm a strong proponent of educating the staff in our office. Our staff in our office is educated on pretty much as I can possibly educate them on. I don't think you have to be a lawyer to be educated, right? You guys don't have to be a lawyer to understand a lot of this stuff. Seminar preparation, followed by detailed diagnostic. We're going to offer you guys at the conclusion here the opportunity to set up a time to meet with either myself or Ed at no charge. So no charge for the consultation and no obligation, right? The opportunity to meet with either myself or Ed, but what we ask is that you bring in your personal information. So your name, your family information, your asset information, and what you're concerned about. You say, hey, I'm really concerned about these 3 things. So write those down and bring them in. Detailed diagnostic, followed by the first meeting is with a lawyer. This is really important because many people out there aren't lawyers. They're doing something else. So you have a lot of people who are selling insurance products or annuities, and they put these presentations on and they invite you in under the guise of doing estate planning, but really what they're trying to do is sell you an annuity. Because I'm telling you, they're going to make a lot more off the annuity than they will the fee they're going to charge you for your estate plan. But we don't do that. You meet with a lawyer. We have no ulterior motive. We're doing legal work. Our attorneys have weekly in-house professional training. The law is changing all the time. Every time a court publishes a case, it potentially can affect our area of the law, and that happens on a daily basis. So we really have to stay up on this. The next step is review of the intake and design by the senior paralegal. So after you meet with either myself or Ed, we collect all the data, we turn over all that data to our senior paralegal. So remember I said the smartest people know everything that they're not good at? Right? I miss some things. I'm not perfect, I'm human, right? So I've assembled a team of people that are complementary to my skill set, and Deb reviews all of my intake work and also reviews Ed's intake work. And then if there's a missing element, she reaches out to the client, or somebody else reaches out and says, hey, we need this information, or we need this question answered. Then the next few steps, this is really interesting because back in 1540, King Henry VIII and Parliament enacted what's called the Statute of Wills. Now this abolished primogeniture. What this means is it used to be that all your property went to your oldest son. Have you guys heard of that? Like, the eldest son, eldest son, eldest son. Back in 1540, the King of England said, hey, I'm doing away with that. You can leave your property to whomever you want because I want to leave it to whomever I want, so I got to change the rules, right? And the problem, though, was if you didn't leave a will, the king got everything. So you need to leave a will. And what has been going on for the last 500 years is lawyers, I'm going to pull back the curtain on how law is practiced here for a little bit. Yes, it's true, lawyers take the Smith will and they scratch out the Smith names and they put the Jones names in there and they hand you, here you go, Mr. and Mrs. Jones, here's your will. Now it happens to be like the Smith will, right? But you've replaced the names. That's how law was practiced for almost 500 years. And that's convenient for the lawyer, and it's form driven. So you say, oh, well, you've got a form for that. Just give me the form, I'll put my name, put in my information, and I'm good to go. We don't do that in our firm. About 15 or 20 years ago, there was a new technology that came out. I will say this is the equivalent of AutoCAD for drafting. You guys know what AutoCAD is? Okay, it's computer-based drawing. So instead of taking pen or pencil to paper and drawing something out, you do it on a computer. We use something called document assembly software. Very powerful, very expensive, very resource intensive to create, but I've pooled with about 2,500 other lawyers in the United States, and we have something called document assembly software. Here's the advantage. You walk out with an estate plan that is absolutely, totally customized to your situation. And we can do that for 1/10 of the cost it would have to do manually, right? Our estate plans used to cost 10 times as much 30 years ago. Next step is meeting to sign the documents. That's 11 steps. The 12th step is where many lawyers fall down, and this is our number 2 mistake, by the way, is continuing follow-up. Because it is true that when you create your estate plan, at that moment in time, it is appropriate for you in your situation. Right? You go 10 years forward. I mean, think 10 years ago, 20 years ago. Are you in a different place than you were 10 or 20 years ago? Absolutely, right? So estate planning is not an historical event. It is something that you need to continue looking at. So in order to facilitate that, we do 3 things that other law firms don't do. Number 1, we charge flat fees. We don't charge hourly fees for estate planning. I don't like hourly fees, because I get the feeling, I'm a very efficient, motivated kind of energy guy. I get the feeling that if I hire someone to do something on an hourly basis, I'm gonna have to pay for their inefficiency and laziness, and I just don't wanna pay for that, right? Number 1, flat fees. Number 2, no charge calls. You call about your estate plan, no charge. Has anyone here hired a lawyer? Yeah. Every time you call the lawyer, what do you get? You get a bill, right? I don't like that. So we stopped doing it. The third thing is a free review with a lawyer every 3 years. Free review with a lawyer every 3 years. Now, other lawyers do those things, those other 2 things, but they typically charge you year over year. We don't do that. We've just chosen not to do that in our firm, and you know what? It works for us. So that's the distinguishing thing between us and other lawyers. Let's look at what other lawyers' process involves. Right? What do other lawyers do? I know because I train them on a lot of technical things. This is what other lawyers do. You get your first attorney meeting. They take the Smith trust. They scratch out, they look at it. Okay, this looks appropriate. Let me take the Smith name out and put the Jones name in. Here you go. You meet with the lawyer. The lawyer's wearing a blue suit. I'm wearing a blue suit. But the lawyer's wearing a blue suit, a white shirt, and a red tie. That's the sit down, shut up, and listen to me outfit, right? So here you go. This is what's appropriate for you. There's no learning. But let's face it, it's really important to learn about this stuff because this is your legacy. When you leave this earth, do you know what you leave behind? Your stuff and your estate plan. I mean, your family, right? But what we're talking about here is your stuff and your estate plan. That's it. What if you go online? What if you go to an online service? What do you get? Or you go to a paralegal. You're getting word processing. You're getting no insight. You're getting no wisdom. You're getting nothing except word processing. So which estate plan is likely to open up like these parachutes? And that's an Air Force. It's a C-130. Which parachute and estate plan is likely to open up? I think ours will. Mistake number 8, failing to address what will happen when you are incapacitated. Now, why do I say when? It's if, right? If. You're power of positive thinking. You're the glasses 20% full because there's an 80% probability that you will have a period of incapacity before your death. And if you think about the people who are sick that you know or care about or who have passed away, oftentimes there is a period of disability before death. Sometimes there isn't. A good friend of mine passed away the night before last of a heart attack in his sleep. A blessing for him, very difficult on the family. Let's talk about all the things we didn't talk about that go in a trust. So we've talked about a living trust. Remember, we put our house and our stocks, our bonds, our mutual funds in the living trust, and Kevin's the successor trustee, right? And we talked about that, but we didn't talk about our IRAs, our 401ks, our TSPs, our TSAs, all those. Whenever I use that term, I'll just say IRAs, even though a TSP is not an IRA. annuities and life insurance. So what do? Well, we have something called a durable power of attorney. So I'm going to draw a distinction between a power of attorney and a durable power of attorney. What's the difference? A power of attorney stops being effective when you become incapacitated. Yeah, a power of attorney stops becoming effective when you become incapacitated. A durable power of attorney is the type of power of attorney that continues to be effective after you become incapacitated. And if you think about it, what type of power of attorney do we want in this case? Well, if I get sick, I want my wife, right, to do all these things for me. I want a durable power of attorney. So this, kind of goes to, well, if I just go on the internet and pull a form down, well, you better choose wisely, right? You got to make sure you get that right form. But the durable power of attorney is what you want, not the power of attorney for this context. And there are two types of powers of attorney, by the way, durable powers of attorney. There's the long form and the short form. The short form is 2 pages. You may have a 2-page durable power of attorney. Our durable powers of attorney run about 24 pages. Why is that? We don't like killing trees. We're not just needlessly running up costs. Here's the real world issue. When you go to the bank, XYZ Bank, and you need to close somebody's account and open up a new one for whatever reason, if you take that 2-page power of attorney and walk down to the person who looks like she's 12 years old behind the computer terminal, right? And you say, I'd like to close this other person's account and open another account using this durable power of attorney, they say, well, let me see it. And what the short form durable power of attorney says is it says, I grant my agent the following powers. Banking powers, period. And then it says at the bottom, and these powers are all contained in California Probate Code section, blah, blah, blah. The problem is the person sitting there who looks like she's 12 says, well, it says banking powers, but it doesn't say you can open and close an account. That power is actually included in the California Probate Code, but you've got to go dig up the California Probate Code, and here's what happens. The person says, I'm sorry, I'm going to have to send this to legal. And then it's like, you can't get anything done. So our durable power of attorney says, banking powers, the power to open accounts, the power to close accounts, the power to blah, 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 blah. But it's a paragraph. So she goes, oh, well, there it is. It's the power. Great. Well, we can go ahead and do it. The other thing to be mindful of is I mentioned a nursing home and it running 5, 8, 10, 15,000. It's all over the map on what a nursing home costs. If a person has a stroke or dementia, Parkinson's, Alzheimer's, and needs to go to a nursing home, there are public benefits available, and there are 2 big groups of public benefits available: Veterans Aid in Attendance and Medi-Cal, or Medicaid in other states. Aid in Attendance says if your income is less than your in-home or your health care needs. So if I'm at home and I earn $2,000 a month and my cost of care is $3,000 a month, right? So I'm spending more than is coming in, and I'm poor, and I'm a wartime vet, I can apply for aid in attendance, or I'm a surviving spouse of a wartime vet, and get maybe $1,700 or $1,300 a month to help me stay in the home. That's a great thing. The problem is if the vet or the person who is seeking the care is disabled and can't make any gifts of property, the durable power of attorney for property can contain gifting language to make those transfers. It's very important that under California law, the durable power of attorney has to contain affirmative gifting language, otherwise you can't make a gift. So that gifting language has to be explicit in the durable power of attorney. We did a study over a couple-year period. 80% of the durable powers of attorney that we reviewed did not have gifting authority. So it's very important that you consider having that. Now, that being said, some people say, I don't agree with that type of planning. I don't think people should be a burden on society. I don't think you should, and I'll put game the system in air quotes, so goes the argument. I think people should pay for their own care. I'm not advocating one way or another. All I'm saying is, look, this is out there, and you guys as a family or an individual, you decide which way you want to go. But I'm not advocating one way or another. Many attorneys say, I don't even want to learn that area of the law. Many attorneys that practice estate planning, I don't want to learn that area of law because I don't believe in it. As a lawyer, I think we're not being an impartial advocate, if that makes sense. I think our job is to educate the client. Let's talk about healthcare. Let's talk about who makes healthcare decisions for you if you can't make them for yourself. That's on an advanced healthcare directive. That's the document that we use. And what the advanced healthcare directive says is, it says if I get sick, somebody else makes healthcare decisions for me. My wife, my kids, whomever it might be. It also says who disposes of my remains after I'm gone, which you might think, well, that's pretty easy. We had a case where a woman came in, she said, look, when mom died, mom didn't have an advanced health care directive. Okay. Mom stayed in the morgue a few days, became a week, became 2 weeks. The kids never agreed. Finally, the morgue just says, you know what, we're going to cremate the remains, and we're going to give out 5 little urns, one for each child, 1, 2, 3, 4, 5. The 5 kids got 5 little urns. That's what happened to mom. Whenever I talk about this remains, my wife says, you know what, I don't want to get eaten by bugs. I want to be cremated. I don't want to go into the ground and get eaten by bugs and worms. I want to be cremated. I want my ashes put in an urn. I want to be in a little niche in a mausoleum with marble. I want people to visit me. I don't want any of that. I don't want any of that other stuff getting buried. Say, okay, great. If you try and have that conversation with your kids, good luck. Hey, when I die, they go, Mom, Dad, nothing's going to happen. We don't want to hear it. So it's really important to think about this and actually kind of write it down. So in our estate plan, there's a place for you to actually write down, these are the people I want as my pallbearers, this is what I want to have happen with my remains. At least you've written it down and they see, okay, this is what Mom and Dad wanted, because you can't have that conversation with your kids. The next document is a HIPAA authorization, not this HIP, right? It's HIPAA authorization. You guys know what that is? Medical privacy, right? If I go to my wife's physician and I say I would like my wife's medical records, what do they say? No. If they give them to me, it's a $50,000 fine. That's why they're really worried. Here's the curious thing, though, and I have yet to see any HIPAA authorization comply with California law. The HIPAA authorization must be in 14-point type. Do you guys know what that means? The typeface is slightly larger than 12-point type, so it's almost like a headline on a newspaper. I told this to my optometrist a couple weeks ago, and she frantically wrote it down. She's like, oh, we need to get that HIPAA authorization fixed. But that's in the California Civil Code. The HIPAA authorization is a separate document than the Advanced Healthcare Directive. 2 reasons. One, it's got to be in 14-point type. Secondly, the people who have access to your health information, you may not want them to be the same people to make healthcare decisions for you. If you have a home health care worker, or maybe you've got, in the case where my wife is the primary caregiver for her mother, our youngest daughter helps out her grandmother, well, she might be a good person to be on the HIPAA authorization, but not necessarily be burdened with health decisions. But if she's got to take grandma somewhere and needs to run back in to pick up something, it kind of makes sense to have her on there. The third document is a living will. And a living will says, essentially, it's okay to let me go. And I'll tell you a little story. When my grandmother, I was very close to my grandmother, she had a heart attack, and my grandfather called 911, and the paramedics arrived. She had a very faint pulse. She was not breathing. And the paramedics do what? They revive her. Take her to the hospital. She's in the hospital. I go to the ICU. The family arrives. I look at her, and I don't know if you've seen somebody after they passed away, but they don't really look like the same person, and it's really hard to describe. They look like a slightly different person. I was convinced her soul was gone. And it took my dad and his 2 brothers a week to terminate life support because they didn't know what to do. They never had the conversation with Mom. And to this day, my father, 15, 16 years later, he asks me every couple of years, did I do the right thing? Because he was the one who had to decide, by the way. His 2 older brothers say, oh, we can't do it, it's too emotional. But he was the one who had to make that decision. And it's still, I know it weighs on him. I think he did the right decision, but it still is a difficult one. A living will says, it's okay to let me go. So if you can't have the conversation with the person who's going to make that call, I think that would have helped my dad if my grandmother had had a living will. On that happy note, we're going to watch a video. Do you guys remember Seinfeld? There's a scene in here with a lawyer with a blue suit and a red tie and a white shirt. We do not conduct the interview like that, I tell you, when you meet with us.
You ever seen the movie The Other Side of Darkness?
No.
It's about this woman in a coma. Well, I couldn't finish watching it, so I want you to read this.
I, Cosmo Kramer, having just seen the movie The Other Side of Darkness, and not wanting to be in a coma like that lady in the movie, hereby want Jerry Seinfeld to remove my life support, feeding machine, lung blower, etc., etc., etc.
Can you do that for me, buddy?
Well, I don't know if what you have here constitutes a legally binding document.
Well, I'm gonna type it up.
Yes, well, of course, but even so, you may want to talk to a lawyer.
Well, Jackie Childs, he put a restraining order on me. I'm not allowed within 200 feet of his office. I couldn't even give him his Christmas present. Did you take this out of the garbage?
Yeah, it's still got some spring in the strings.
Jerry, this is a piece of junk. How are you gonna be the executor of my living will? You see, you can't let go.
Trust me, Kramer, given the legal opportunity, I will kill you.
Wish I could believe you. Hey, Elaine, do you have some free time tomorrow afternoon?
Me?
Yeah, because you're perfect. You're a calculating, cold-hearted businesswoman. And when there's dirty work to be done, you don't mind stomping on a few throats.
Oh, come on.
Situation number 4. You're breathing on your own, you're conscious, but with no muscular function.
Well, would I be able to communicate?
I don't see how.
I don't like the sound of this one.
Yeah, let's pull the cord.
Yank it like you're starting a mower.
Moving on. You have liver, kidneys, and gallbladder, but no central nervous system.
Well, I gotta have a central nervous system.
Okay. 1 lung, blind, and you're eating through a tube.
No, that's not my style.
Boring.
All right, you can eat, but machines do everything else.
I'd stick.
Yeah, stick. Because I could still go to the coffee shop.
That's right.
Oh, Jerry, listen. You know, I saw the rest of that movie, The Other Side of Darkness. The coma lady wakes up at the end.
Oh, I wanted to see that. Thanks. Thanks a lot.
I didn't know it was possible to come out of a coma.
I didn't know it was possible not to know that.
How was Eric Roberts as the husband?
Oh, unforgettable. All right, I gotta find Elaine. You know, she's gonna pull my plug.
Hi. How's he doing?
He's been sleeping a lot. He's still groggy.
Well, I thought a movie might cheer him up. I got him a Gene pick.
What happened to Vincent?
I'm kind of off of him. Outlet. Ah.
Good stuff. Good stuff. Mistake number 7, not protecting your beneficiaries from themselves. Half of all inheritances are squandered, gone, into thin air, quickly. Half. Has anyone here known anyone who's inherited money and blown it? Yeah, there you go. Right. So what do? There are 2 schools of thought. One is, I'm dead, I don't care. The other school of thought is, I worked too long, too hard for this money, and I just don't want to have it squandered. So I think of my son, who's 21 and at Chico State, and if he inherited a big pile of money, what would happen? Party, it'd be gone, right? So what have we done? Well, instead of just giving it to him, we put it in a trust and we're doling it out. And we'll get into that a little bit later on the next slide. But what we do is we trust our trust instead. We put that money into a trust, and we can name Kevin, we can name over there, hey Kevin, we can name Kevin, we can name a trustee in Nevada, so we avoid income tax on the accumulated income in the trust. We can do a lot of different things, but the bottom line is the money does not go to the beneficiary. The money stays in the trust and is doled out as the trustee sees fit. What if this beneficiary is not over the age of 18, but what if a 10-year-old inherits $100,000? What happens? Well, there are two possible outcomes. One is a guardianship. And a guardianship, unfortunately, costs about the same as a conservatorship, which is about $10,000, $12,000 to start, about $6,000 every couple of years. It doesn't make a whole lot of sense if you have a $100,000 inheritance and $12,000 in legal fees. I mean, it makes sense for the lawyer, right, but not for the minor beneficiary. So what we do is we take that $100,000 and the judge will put it into what is called a blocked account. And how old, and that money will be held in a blocked account in a CD getting how much interest? Right? Because that's all it's going to go into is a CD. Going to get 0 interest. And when that child is how old does the child get the money? How old? 18. You're an adult at 18 in the state of California. You get all the money at 18, and then the money's gone. So if you said, Jim, you know what? I don't have any minor beneficiaries. My family is absolutely perfect in every way. We don't need any of this stuff. Mistake number 6 is not protecting your beneficiaries from third parties. Now, what am I talking about with third parties? I'm talking about other people. I'm not talking about the beneficiary blowing his or her inheritances. I'm talking about the potential divorce, the creditor. And I'm not talking about not paying your bills. I'm saying you being held responsible for something that's not your fault. So how do we protect it? We're going to go through 3 case studies. We've got Bob Jr. He has what we call a high maintenance spouse. What does that mean? Spends money. Likes to spend money. He's a physician. He's in a risky business. And a second estate tax. Bob has more than $11 million in assets. Bob has a beach house in San Diego on the water. He's got an apartment in San Francisco, and he's got his home in El Dorado Hills, right? There's a lot of real estate there, huh? Kind of expensive stuff. He's got $10 million in real estate, pretty easy. If he inherits $1 million from his dad, 40% tax on that $1 million. So if he inherits $1 million, $400,000 goes in taxes. We have Jane. She lacks financial experience and has what we call a problem marriage. So I have a client who came to me and she says, Jim, I went to your presentation. I have a Jane. I said, well, tell me what's going on. She says, well, when Jane's father passed away, she inherited a whole bunch of money, and her husband got his hands on the money and bought a truck and a bass boat and spent all the money, and it's gone. So Jane's come to me and Jane says, Mom, I've been working hard my whole life. I'm 60. I've been working hard cleaning motel rooms and cleaning houses as a house cleaner. I'm worn out. I can't do it anymore. I'm really worried that if I inherit from you, my husband is going to get his hands on the money. So what can we do? We'll talk about a solution for Jane. And then Phil, we have a lot of clients who are getting older, and they may have special needs children that they chose not to institutionalize, because back in the day, that's what happened to special needs children. But special needs children that the client chose not to institutionalize, the client's in their 70s and 80s, and now they've got a 50-year-old child who the client says, what's going to happen to my son or daughter if something happens to me? So we'll talk a little bit about that. So for Bob Jr., and in your materials we talk about this, we use what's called a personal asset trust. So here's what happens in the real world. When Bob Sr. passes away and Bob Jr. comes into the office to pick up his $1 million check, who comes with Bob Jr. to the appointment? The wife? Right. And what does she say to Bob? Okay, now that $1 million check, where's that going to get deposited? The joint account, right? So what happens if it gets deposited in the joint account? Is it this separate property inheritance? Does it become community property? Well, actually, the answer is it might. But the problem is, if there's a divorce later on, there's going to be a fight over that money. Was it really community? Was it separate property? That's what we call in play, and a good chunk of it will end up going to Bob's future ex-wife. So what do we do instead? Well, what we do is we take that $1 million, and this is a trust. Bob Sr. has created this trust, and this is the caterpillar that becomes the butterfly, so to speak. So this is Dad's trust, and down here is Bob's personal asset trust. So Dad has to create this trust, and we put $1 million in here, and Bob's the trustee, and he can take money out anytime to buy his Ferrari or whatever he wants to buy. He can take money out anytime. This is fully accessible to him, but he doesn't own it. The trust owns it. That's not community property. That can't be community property because only married people can have community property. You can't have community property with an inheritance trust and a spouse. Okay, that's just not going to work. And then if Bob says, "Oh, whoa, there's a lawsuit," on one of my commercial properties, there's a guy who this is actually kind of a true story. A client came in, he says, "Well, I've got a tenant who wants to take highly toxic, flammable stuff and transfer it from 55-gallon barrels to 5-gallon containers." I said, "You've got other tenants there. They need to do that in a single type thing, because if that catches on fire and burns down all the other tenants' businesses, guess who's going to get sued? The landlord. It's not his fault, but you're still responsible." So Bob sees a lawsuit coming down the road. What he does is he calls the trust protector. And this is a trust protector here. A trust protector is new to American law. It came from England about 15 years ago. When we talk about living trust, I mentioned that there are irrevocable and there are revocable trusts. A living trust is a revocable trust. You can amend it, you can revoke it. Bob Sr.'s trust, a revocable trust. Down here, Bob Jr.'s personal asset trust, and this is in your materials, the personal asset trust. If you're interested in talking about a personal asset trust, it's on the bubble here, so you can check the box, the little bubble there. Bob Jr.'s personal asset trust is created out of Bob Sr.'s personal asset trust. And there's a trust protector. Now, the reason we have a trust protector is if you have an irrevocable trust and you need to remove a trustee, or you need to change the terms of the trust, or you need to move the trust to Nevada, to do that, you have to get a court order, right? You have to get a court order to do that. A trust protector replaces the need for a court order because the trust is written in a way that says there's this separate independent party, which is oftentimes a lawyer. I'm trust protector on a lot of trusts. Sometimes it's an accountant, but typically it's a professional that is not associated with the family in any way that can come in and modify the trust. So what Bob Jr. does is he picks up the phone, calls the trust protector and says, "Hey, Mr. Trust Protector, please remove me as trustee and appoint Kevin, my best friend, as trustee." So Kevin's the trustee now. And what we say is, "Kevin, don't give me any money," right? And that money's sheltered and protected from creditors until the smoke clears. The trust protector removes Kevin and appoints Bob Jr. back as trustee of the personal asset trust. Great trust, great asset protection tool. That is a personal asset trust. Let's talk about Jane. Jane, we have what's called a dole it out trust. So remember, Jane says, "My husband took my inheritance. I don't want it taken away." So Jane comes into the office, and this has happened in other cases similar to Jane. We come in and we say, "Jane, you've inherited $1 million. Now here's the problem. Here, I will just tell you, here's the problem when people inherit a number like that. $1 million is an abstraction. If you think of one ping pong ball, great. You think of 10 ping pong balls in a row, okay. And you think of 100, which is 10 by 10, that's 100, and then you stack 10 of those, that's 1,000, okay? That's about as far as my brain can take numbers, I'm just telling you. And when you get to $1 million, it's an abstraction. I've seen people, they inherit $1 million and they go, "It's an unlimited amount of money," right? It's finite, but it's big, but it's finite. So here's what we do with Jane. We sit her down and we say, "Jane, you're 60 and you've inherited $1 million. Here's what we think. We think that you can take out 4.8% a year and never run out of money." And she goes, 4.8% of $1 million, I don't know what that is. I wasn't good at math. Well, 4.8% of $1 million is 48,000. And she goes, "Ah." I say, "So that's $4,000 a month. So what we're going to do is, if it's all right with you," right, because you want to get the buy-in from the beneficiary, "how's $4,000 a month sound?" She goes, she starts crying. She says, "It's such a blessing. I can't believe my mom did this for me. I was so worried that this would be taken away from me and I would be destitute. Now I feel safe," right? "Now I know there's a future stream of income, and every time I get that check, I can think how much my mother loved me for setting this up. And if her husband gets a hold of a few $1,000s a month, in 1 month she knows she has another 4,000 coming in the next month." The longer I practice law, the more I like these kind of trusts, because it's a great source of supplemental income for people. You may have somebody that you care about that you want to leave money to who says, "Look, I've got 4 kids and I really have a passion for teaching. I want to be a teacher." How hard is it to raise 4 kids on a teacher's salary, right? But it'd be nice to have some extra money to help out. That's a dole it out trust. The last trust is a special needs trust. And this is a special type of trust. And what this says is, some people have been told you can't leave your special needs child anything. Well, that's kind of partly true. Because if you leave them more than $2,000, they lose their SSI, supplemental security income. They probably lose their HUD housing. They may get kicked out of the regional center. Possible. They'll lose Medi-Cal, perhaps. So what we do is we leave those assets to what we call a special needs trust. That special needs trust is used for things other than food, clothing, and shelter. What is there other than food, clothing, and shelter? There's medical. There's dental. A very common expenditure for special needs individuals in their 50s is dental work, right? Because you kind of have to monitor that and Dental, how much is a dental implant? I mean, how many are there? There's like 8 in your mouth. You know, that could be $50,000, $60,000. It can be a significant expenditure, as well as entertainment. So maybe taking a family trip, you know, whatever the case may be, buying the big flat screen TV with the PS4 and the VR and, you know, whatever it is, but something other than food, clothing, and shelter. I mentioned the trust protector. The trust protector can change an irrevocable trust. So remember, this is your revocable trust, but once that trust becomes irrevocable down here, you just ignore that. We'll talk about that a little bit later. Once it becomes irrevocable, the trust protector can change the trust to conform to future tax laws, future probate law changes. What if you run out of trustees? That happens more than you'd think, right? Especially for a trust that goes on and on and on. We have one trust in our office that was created in 1934. All the trustees are dead, right? We've had to go back to court and put in new trustees. Mistake number 5, thinking your living trust covers your IRAs and retirement plans. By the term IRA and retirement plan, I'm not talking about a PERS or a monthly. What I'm talking about is IRA, 401k, 403b, TSA, TSP, 457. I'm talking about those type of retirement plans. Who gets your IRA or your 401k or your 457 or your TSP when you die? Who gets that? Your named beneficiary. How do we know who the beneficiary is? How do we find out? The record. Where's the record held? Do you hold on to it or does someone else hold on to it? Yeah, that's the institution. This is the biggest difference, folks, between living trust-centered planning, the living trust plan. It's your living trust. You put your assets in the trust, your house, your bank account, your stocks, your bonds, your mutual funds. You can change the beneficiaries at any time, and it can be a secret until you die. You can just sign documents and stick them in your drawer, stick them in your safe deposit box or your safe, and you can change that and no one is the wiser. Here's the difference. With an IRA, life insurance, annuity, 401k, 403b, whatever it is, you have to fill out a piece of paper and you have to deliver that piece of paper to some company who has to accept it. Very important, they've got to accept it. So it's not good enough just to sign the beneficiary designation and keep it in your possession. You've got to submit that to the company, and then the company has to find it after you're gone. And they do get lost. They do. Well, we can't find. We have no record of it. Well, I sent it in. That's why it's good to have a copy, an endorsed copy from the company. There are 2 nonprofits in the United States. I'm going to circle this back with retirement accounts. This will make sense in a few minutes. There are 2 nonprofits in the United States. One group of nonprofits, one group of organizations that does not pay tax is charities. What other group of organizations or what other massive organization, it's huge by the way, doesn't pay tax? Church. No, church is a charity. What other, we just had a change in government, right? It's government, right? The government doesn't pay tax, they collect tax, right? That's why they print money, so they can collect tax. So if you have $1, that doubles every year. Let's say you have, boy, this is great. You didn't know this was an investment seminar, right? Just guaranteed 100% rate of return tax-free. $1 becomes 2, becomes 4, becomes 8, becomes 16. After 21 years, you will have $1,048,000. It's amazing. What if you take 40% tax out? So your dollar becomes $1.60, $2.56, $4.10. How much money do you have after 21 years? 600? Okay. That's wrong, but since you've been such a good sport about being trustee, I'm going to pay you your trustee and participation fee and milk chocolate. Who else wants some chocolate? Any guess? Come up with a number. Give me a number.
What it earned?
No, what the total is. So $1 doubled every year is $1,048,000, but what if you take 40% tax out? How much do you have left?
I'm going to say about 350.
350? No, you keep going down. Take off a 0.
About $60.
60, a little bit higher than 60. It's $12,000. Here's the problem. Isn't that amazing? It's $12,000. Here's the problem. I don't know the relationship between those 2 numbers. They're too big, right? So I'm going to put it in terms that we can understand. It's a difference between $100 and $1.15. That is the negative drag of taxation.
So here's our problem. You work, You save, you grow your 401ks and your IRAs. Maybe you both have an IRA or 401k. If one of you passes away, the other can roll the IRA into theirs. No problem so far until the last spouse passes away. To get the most after-tax money, the kids should take the money out over their lifetime. However, they can take the money whenever they want. Whenever the kids take a distribution, the IRS gets taxes. And if that's not enough, you now have the Supreme Court who ruled that your kids' creditors can get assets in an inherited IRA. Spendthrift kids, the IRS, and now creditors, ex-spouses, and bad investments. What to do? Enter the IRA Trust. On the death of an IRA owner, funds can be protected in an IRA trust. Now we can have the kids paying less tax by taking the money out over their lifetime. We can let them have more if they need it. We keep the IRS at bay, and the inherited IRA is protected from creditors. An IRA trust protects the money from the kids and the kids from the money. IRA trusts are a good form of asset protection.
I prefer $3 million. So here's how we get there. Here's how you turn $200,000 into $100,000. Without an IRA inheritance trust, Tom, age 50, inherits a $200,000 IRA, takes all the money out, buys a truck and a bass boat, and parties until what? It's gone. I have nothing against truck owners or bass fishermen or bass boat owners, but it's pretty easy to spend $200,000 on a truck and a boat, I can tell you. Here's what happens in the real world. Tom walks up to XYZ financial company and says, yeah, my dad passed away, and here's his death certificate, and here's my photo ID. They're going to ask him, well, what do you want to do? He says, well, what do you mean what do I want to do? What are my options? They say, well, you can take the money out, and he says, I'll take that option. They go, okay, well, we just have to ask you one question. Are you subject to backup withholding? And he says, what's backup withholding? Well, if you're not subject to backup withholding, we only keep 10% or $20,000. And we give you a check for $180. He says, I like that. He says, if you are subject to backup withholding, we keep 40% and give you a check for $120,000. And he says, I'm not subject to backup withholding. Give me the $180. He takes the $180. He buys a super duper Ford Platinum F-250. How much are those? 80. Thank you. There's someone who always knows, right? always one in the crowd. $80,000 truck. Can he spend another $100,000 on a bass boat? He can spend $100,000 on a couple of engines for a bass boat. He spends the money. The following January, he gets a 1099-R, and he takes it to his accountant and he says, well, I'm making $150,000 a year. And I got this thing, this 1099-R. I don't know what to do with this. It says $200,000 on it. And the accountant goes, we're going to have to add $200,000 to your income. He goes, what? He says, well, your taxes now are over $100,000. He says, well, I don't have the money. If you don't have the money, do you still owe the tax? Yeah, there you go. You guys, yeah. So what do we do? What's a better solution? So we use an IRA inheritance trust. I want you to think, an IRA inheritance trust is not a living trust. It's a special kind of trust approved by private letter ruling from the IRS in 2005. This is not a living trust, but I want you to think about it as a living trust for your IRA. That's a good way to think about it. This is kind of the living trust for your IRA. Without an IRA inheritance trust, the $200,000 is doled out to Tom until he's in his mid-80s. Assuming S&P 500 returns, all I did is I assumed that he inherited $200,000 in 1982, right? Put it in S&P 500. After taxes and management fees, by the time he's 80, $2 million in distributions after taxes, and he still has $1 million left over. That's what we call a lifetime of checks. Here's how it works. I prefer $300,000 over $100,000. Here's how it works. In your materials, we have, if you open these up, you will see a red bar, a sheet with a red bar on it. Now I will tell you that most lawyers don't have a clue about what we're going to talk about. You're going to know more than the vast majority of estate planning attorneys when you walk out the door here. I know this because I teach them. These are certified specialists in estate planning, don't know this, by the way. So it's very rare that you find an attorney who understands this stuff. The red bar. When you inherit an IRA or 401k, 403b, TSA from somebody other than your spouse. So we're not talking about spouse. If you're a spouse, you can roll it over, as the video suggested. But if you are not somebody's spouse and you inherit an IRA, you can't roll it over. You have to start taking money out by the December 31st of the year following the person who died, that person's death, right? So if a person passes away in any given year, the following year by December 31, the beneficiary has to take something out. What is that something? Well, that something is age dependent. And if you look here, it starts at 0. So if a person dies this year and leaves an IRA to a person who was born this year, that person's age is 0 at the end of the year. And by the following year, they have to take out some money. So here's how this works. If you look at the middle of the page, you've got a 50-year-old, and that number's 34.2. Now, the government makes this really easy. You ready? You take your minimum distribution the following year is 1 divided by this 34.2 minus 1. See how easy it is? Which is 3.01%. So here's how this works. If a person inherits a $200,000 IRA this year, $200,000 in a pot, they wait a year to take a distribution out. Let's say it goes up to $220,000. Tom takes out 3% of $220,000, which is about $6,500, $6,600. What stays in there? 204 or whatever the number, 204,000, 203, 4 stays in there. That 203 grows another 10% the following year. You see how this works? That's why I put that dollar doubling every year. What ends up happening is the IRA grows faster than the money coming out, and the growth inside of the IRA occurs tax deferred. It's not tax-free, but it's tax deferred. If it's a Roth, it grows tax-free. So if any of you have Roths out there, this is actually a better plan for a Roth than it is for a regular IRA, because it's just explosive growth. But when you plot this out, by the way, this number 34, this amount of money is going to be doled out for 34 years. And if you leave it to a 20-year-old, instead of, if you leave it to Tom's kid, a 20-year-old, it's going to be doled out for 63 years. Think of the compounding effect on that. You know, it was Albert Einstein who said the 8th wonder of the world, compound interest, right? So as a general rule of thumb, if you leave an IRA to a 50-year-old, you take the dollar amount of the IRA and you multiply it by 5. That's the amount of money that the 50-year-old will receive over their lifetime. So if you leave a $100,000 IRA to a 50-year-old, conservatively, this is kind of a wild example, this $3 million, but conservatively at a 5.5% rate of return, that 50-year-old will get $500,000 in checks, 5 times the amount of the IRA. If you leave it to a 20-year-old, they'll get 10 times. And that's based on a 5.5% rate of return. So this has been a very powerful tool for clients where they leave the IRA, instead of it getting blown, this becomes a lifetime of checks. Let's look at this. If you flip this chart over on the yellow side, this is a really curious thing. This is your IRA, so well, no show of hands, but if anyone's reached the age of 70, you know what it's time to do. If you have an IRA and you're 70, you got to take money out of the left pocket and put it in the right pocket and pay tax. That's called your minimum distribution. And when you, if you are 70 at the end of in the year in which you turn 70 and a half, again, they make it easy, your minimum distribution is 3.65%. At 89, your minimum distribution is 8.3% on your IRA, right? But if you inherit an IRA, look, here they say you're going to live 27.4 years if you've earned the IRA, but if you've inherited the IRA, you're only going to live 17 years. This is the government, right? It doesn't make sense. This is fiscal policy, fiscal meaning money. This really has no basis in reality. If you inherit an IRA at age 89, your life expectancy is 5.9 years. Your minimum distribution is 16.9%. So if you leave your IRA to Aunt Mabel, think twice. As a general rule, it's better to leave IRAs to younger people. So you've got 3 choices with IRAs. Do you leave it to the individual? If you leave it to the individual, there's a 50% probability they will yank all the money out and blow it pretty much right away and get in a big tax hole. We see this a lot. Remember the top 10 estate planning mistakes we see a lot in our office? People come in, they say, well, I know I need some help administering Dad's trust, but I just cashed in his IRA yesterday. Once you cash in the IRA, there's no 60-day window, right? On your own IRA, you can pull the money out every 12 months and put it in a new IRA. You can't do that with an inherited IRA. Once the money comes out, it's out. Creditor protection, no. Living trust, with rare exception, and please pay attention to this, with rare exception, if your lawyer has advised you to leave your IRA to your living trust, you need a new lawyer because they fundamentally do not understand this area of the law. This is not an approved strategy for stretching out the IRA that we're talking about here. It is what we call an off-label strategy. It's not approved. This document we're using, the actual document's been approved by the IRS. You're not going to have problems with this. This particular document's been approved. The problem with the living trust, no two are alike. This is a fairly rigid trust, right? And the living trust, you could say anything you want. You can also inadvertently amend your trust by writing on it and cause problems with the stretch out if you leave your IRA to your living trust. So we recommend a separate IRA inheritance trust, and it provides creditor protection, which is really cool. Divorce protection. Mistake number 4, thinking your living trust is enough. Estate taxes are due 9 months after death. So you pass away, and you've got, if you have an estate over $5.5 million currently, or $11 million if you're married, you're going to pay some estate tax. This eliminates estate tax for 99.7% of Americans. So if you're one of the lucky few where you've got a taxable estate, you need to bear in mind that that's due 9 months after death and the tax is 40%. If you have a ranch in Oregon, you are subject to Oregon inheritance taxes, even though you're not an Oregon resident. Oregon residents are subject to an additional inheritance tax. It's up to 16% on amounts over $1 million. So you don't have to pump your own gas, but you do have to pay a death tax in Oregon, right? And if you have property in Oregon, you're subjecting that property to inheritance tax as well. There's actually a way to opt out of that. But without some proper planning, you're going to be subject to the inheritance tax. Is anyone here married and has a trust? Anybody here? Okay. So if you're married and you have a trust, you likely have what's called an AB trust. And what this says is, on the death of one spouse, thou shalt divide the property into an A trust and a B trust. Both these trusts are for the surviving spouse. Both these trusts are for the survivor. But the A trust contains the alive spouse's half of the property. And the B trust contains the buried spouse's half of the property. And the A trust contains the above ground spouse's property, and the B trust contains the below ground spouse's property. That's how we remembered it in law school. So here's the problem. The problem with this is you create a separate irrevocable trust that can't be changed. You create a separate irrevocable trust. You have to file an income tax return every year. It's $1,000 a year. And you have some negative capital gains tax consequences. The reason most of us did these AB trusts was to avoid estate tax, which no longer affects 99.7% of Americans. So for most people, they don't need an AB trust because they're no longer subject to the estate taxes. And this is also just a big hassle, frankly, right? You lose your spouse, and now you've got to go through all this hassle and paperwork in kind of the twilight years of your life. And most clients, these elderly people come into my office, are like, I got to do what? This is crazy. I have to do this, and it's of no benefit to me anymore. So what we encourage clients to do, if you have a trust and you're married, bring it in. We'll take a look at it. We'll tell you, hey, is this an AB trust? If that's your trust, it looks like an AB trust. It's awfully thick. But if you have an AB trust or not, and what's an appropriate course for you to take. Asset and income protection. If any of you are concerned about getting sued or protecting your assets, which if you've never been sued, you just don't know how bad it can be. And the clients who have been sued, especially when it's not your fault, very frustrating, very frustrating. We have a lot of asset protection strategies. The ironic thing with asset protection is if we put it on our website or we market the strategies, it makes the strategies less effective because they're attacked. They go, oh, we looked on your website and this strategy is just for asset protection. So we don't put any of those strategies on our website. It's something that we do one-on-one. We do have some income reduction strategies. You can use Nevada trusts. Something called a charitable LLC is a really exciting tool. If you have, does anyone here have a California LLC? Anybody here? Okay, if you have a California LLC, you can save some taxes by essentially reincorporating in Nevada. Mistake number 3, believing who you name to act as trustee will know what to do. Now I underscore the word trust because the single biggest disadvantage in naming Kevin as my trustee, is it okay if I pick on you? You seem
Yeah.
like, hey, you're a good sport.
And sorry about everything I did with your money.
See, you're a great example. You're sorry about everything you did with my money. Here's the single biggest downside. There is no court supervision. There is no court oversight. It's its greatest attribute, but also potentially its deadliest consequence, right? Is the fact that somebody can steal all your money and you have to go to court to remove that trustee. The advantage with our plans is we have the ability to incorporate a trust protector. Now, a trust protector can remove a bad trustee. So if the bank calls and says, hey, Kevin's pulling out $15,000 a day cash, he should be removed as trustee, the trust protector can step in and remove Kevin as trustee. Thank you, Kevin. I'll give you some more chocolate. You want how about $10,000?
I'm good.
You're good? You don't want $10,000? Okay. So there are three types of trustees. First of all, there's the individual trustee. There's a person, the oldest child. Tag, you're it. Has anyone here served as a trustee of somebody else's trust? Okay, all right. So you know what I'm talking about. So most people don't have a clue about what to do, so we wrote the trustee manual, checklist and guidelines for the successor trustee of a living trust. This is a primer. This is not a substitute for legal advice. This just kind of gives you an outline of, this is the roadmap of where we're going on this. It's an educational tool. So that's the first type of trustee, is an individual trustee. The second type of trustee is a private professional fiduciary. What's that? That's somebody who's registered with the state of California as a private fiduciary. They're bonded. They're deemed trustworthy by the state of California, and they serve in a professional capacity with many, many clients. The advantage to that is you get one-on-one personal service. The disadvantage is if you're the same age as the private professional fiduciary and you name that person in your estate plan, and 25 years later you have a need for that person, they may be in worse shape than you or they may be dead themselves. So if you name a private professional fiduciary and they're close to you in age, you need to monitor that, right? If you have a need for immediately for the services, you don't have as much of an issue. But if you do choose, if you don't have someone and want to choose a private fiduciary, that's something you need to pay attention to. The third alternative is a trust bank, and those come in two flavors: in-state banks and out-of-state banks. So there are big national banks that cover all the states, and then there are other banks that stay just in their state. So there are certain banks that stay just in Nevada, or just in South Dakota, or just in Alaska, and there are other banks that are in every state. If a trust bank is cited in the state of California, if it does business in the state of California, it will subject the trust to California state income tax. Okay? An out-of-state trust bank does not subject the trust to California state income tax. A little food for thought: if you are named as trustee on someone else's trust and they are a resident outside the state of California, the moment you become a fiduciary in that trust, you subject the income of that trust to California state income tax. A lot of people don't realize this, but if you serve as a fiduciary on your brother's Nevada trust, you subject that trust to state income tax. How do they find out? The 1099s, they come to you in California, the Franchise Tax Board is monitoring that. Yeah, it's sneaky, right? And they dig in dumpsters. I hope no one here works for the Franchise Tax Board. Mistake number 2, not keeping up with changes. What kind of changes am I talking about? Well, we talked a lot about changes in the law, but here are the changes. This is really changes in your situation. You, right? This is, hey, it was 20 years ago we did our estate plan. My kids are grown. My daughter's been through 2 marriages, has 3 kids from 3 different dads, and everything's changed. Right?
Just spend the money.
It's just spend it. Just put that bumper sticker that says I'm spending my child's inheritance, right? But keep up with changes. So how do we, this is a picture of Deb, by the way, our senior paralegal. How do we keep up with changes? So how do we do that? Well, number 1, no charge phone calls. Call us. We get calls all the time. Nicole, my assistant, she gets calls, hey, I'm at the bank and I need that certificate of trust. Can you email that over? Sure. Off it goes. No charge. Free review every 3 years. And, this is what we do every day. I don't do a family law case or an immigration case. I do estate planning every day. There's another attorney in our office, Preston, who does trust administration. That's all he does. All that Ed and I do is estate planning. So we stay in our lane. I think that our process is a much better process than other attorneys that I see that try and do a lot of different things. Mistake number one, I want you guys to give yourselves a hand. Really, seriously, give yourselves a hand. I will take a bow. Thank you. You have avoided procrastination. Classic procrastination example is, Mr. Cunningham, I got to get a call, Mr. Cunningham, my dad needs an estate plan. Well, can you put your dad on the phone? Well, no, he passed away a couple days ago, but we need to get things in order. Well, it's a little late. So you don't know when that's going to happen. It does work for you. So that's been a lot of information, hasn't it? So here's what I want to do. I want to give you 2 easy things to remember. I'm going to make it really easy. Do you guys like easy? 1, make an appointment. 2, show up. How hard is that, right? Make an appointment, show up. And what I do is I'd like to invite you guys to stick around. We still have plenty of coffee and treats. And when you meet with someone about your estate plan, I had a good friend of ours come to one of these, and she says, Jim, talking about all this stuff, and you get this questionnaire, you ask for all this personal information, it's kind of like someone looking in your underwear drawer. Like, it's really personal and private. And so I'm going to stick around. If you guys want to chat with me briefly, or Ed, or Nicole, or Nilesh, just to get to know us a little bit, so you've got a comfort level. You've seen a lot of me talk, but if you want a little bit of one-on-one interaction, I'm going to stick around. There's no rush to get out of here. Feel free to hang out. I'm going to open it up for questions, and Ed, if you can get the mic for questions as people ask them. I'm going to open it up for questions, and if you guys want to go ahead and make an appointment.